Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. A lot of things in a divorce are going to have to be equitably divided. It could include bank accounts. It could include items of personal property. Even when we talk about the children, the court is supposed to work out a schedule so that the parents have a fair way that's in the best interest of the children of sharing the life with their kids. What about the marital home? We got to divide that too. And what does the court do if both parties want it? Well, you got to understand one thing. Generally speaking, the court's in the liquidation business. They're not likely, in most cases, to order, well, you get the house and you don't. What the court is likely to do is deal in the values. What I mean by the value is we're going to look at the worth of the home less the obligation. So the court may look at a house that's a $300,000 house because that's what the market value is. $300,000 house, and let's say there's a $100,000 mortgage on it. That means that the value of this asset is really $200,000. So the court is going to do one of two things. The court will either order it sold and split. That way, everybody gets, after cost of sale, everybody gets half of whatever's left. The court could do that. Another thing the court could do is say, look, we're not going to sell it and split it. Husband's going to keep the house, and he's going to get the $200,000 equity. What does that mean? That really means that he benefited $100,000, because remember, of the $200,000, $100,000 was already his. But if he's keeping the second $100,000, the court wouldn't do that unless the court is going to give the other side an additional $100,000 in some other asset, the benefit of the extra $100,000 there. So let's say, for example, we have the $200,000 in equity, and we also have $200,000 in the bank. The court has the ability to say, I'll tell you what, you keep the house. Now you're owing her $100,000, but it's no problem. You're keeping her $100,000. She's going to keep your $100,000 because I'm giving her the bank account of $200,000. Rather than have her give you half and give up, we'll leave it like that. So the court has the discretion to do that. You have to understand, though, that the court will do certain things under certain circumstances if the court feels it's equitable to have one person in the house for whatever reason, maybe sentimental value, or they put a lot of equity of a sweat equity into the house, or one person really wants it, one person really doesn't care, that kind of thing. The court can take it into account. But generally speaking, that's available to the court. The court can also, in certain cases, appoint a receiver to have the house sold and all that. There's different things that the court can do. But in terms of determining who gets the house, normally the court is going to reduce things down to numbers and then divide up the numbers accordingly. If you have any questions about that, reach out. We'll be glad to help you out.